Hello everyone. Now, today we are going to discuss the second part of presumption. In the last video, we have discussed about the presumption, the first part, which was on presumption of fact or natural presumption. And as I said in that video, the second part we are going to discuss is presumption of law. So, second category of presumption. Though presumption of law can be further classified into rebuttable presumption of law and irrebuttable presumption of law. In Bharatiya Sakshya Adhiniyam as well as in the Indian Evidence Act, for rebuttable presumption of law, the word shall presume is used, while irrebuttable presumption of law, word conclusive proof is used. So, we will going to discuss presumption of law, artificial presumption, and presumption of law can be rebuttable presumption of law, which means what is used in the act is shall presume. So let me see where we'll find these words shall presume. Now section 78 of Bharatiya Sakshya Adhiniyam, which was in section 79 of Indian Evidence Act, it's talk about presumption as to genuineness of the certified copies. Remember in the last video when we were discussing about the certified copy of a judgment from foreign jurisdiction, it was a may presume. But when we are getting certified copy from within the countries, from the authorities of the central government or state government, then here the presumption is artificial presumption, shall presume. So 78 says, the court shall presume to be genuine every document purporting to be a certificate, certified copy or other document which is by law declared to be admissible as evidence of any particular fact and which purport to be duly certified by any officer of the central government or the state government. Remember, in many laws, they do say that on many circumstances, you can submit the document by certified copy. For example, under Bharatiya Sakshya Adhiniyam, when we look at the provisions relating to public document, it laid down how to prove public document. One of the ways in which we prove public documents are through certified copy. So when law permit that evidence can be submitted through certified copy, clause 1 make clear whether it is certified from the officers of the central government or the state government, and when the law permit, it can be admissible. A proviso has been added there, and proviso says provided that such document is substantially in the form and purport to be executed in the manner directed by the law in that behalf. So these are conditions that in order to believe that certified copy, the certified copy must be in the same format as the law prescribed for it. Clause 2 says, the court shall also presume that any officer by whom any such document purport to be signed or certified held when he signed it the official character which he claimed in such paper. So, if someone, suppose a registrar has signed a certified copy, court shall presume that the person is holding that possession. Now, why we add this presumption? I said in the last video also, the presumption helps in proving the cases. Presumption helps in proving that documents. If suppose had the presumption is not there, then you need to prove everything. You need to prove whose signature, who signed, etc. Now, once you draw presumption, it's the proof of the matter that this is the true copy of whatever the document of which the certified copy is being issued. And if it's a rebuttable presumption of loss, if the other party is unhappy, other party thinks there is a change, manipulations, etc., forgery, they can give evidences and prove it. So at least it will save the court time, that court should not unnecessarily waste its time in proving some document where presumption can be drawn. So presumption in many ways helps the court to save those time. This presumption is nevertheless rebuttable. So even if we shall presume, it will be considered as proof until unless disproved. And accordingly, in UP State Road Transport Corporation versus Kedar Singh case, court says the certified copy can be proved incorrect if challenged and the original is shown to have interpolarization. So if there are any changes in the copies, if there is a manipulation in the copies, other party has a liberty to prove them. But by and large, when say someone produce some certified copy from the court record or other record, we presume to be true. For example, when a person's file appeal in superior court, the lower court order or decree, etc., they need to get certified copy of it, and with that they submit appeal. Now, if the presumption is not drawn, then every single thing you need to prove. So, in many cases, this presumptions provisions helps in proving the cases. Then we have another section 79, which says presumption has to document produced as record of evidence. So, some document has been produced from court as a record of evidences. There may be, these are all most of the time certified copies. There is a presumption. So, 79 says, whenever any document is produced before any court purporting to be a record or memorandum of evidence or of any part of the evidence given by a witness in judicial proceedings or before any officer authorized by law to take such evidence, or to be a statement or confession by any prisoner or accused person taken in accordance with the law. Remember, under the CRPC 164 CRPC, magistrate used to record a statement of witnesses. It can be of accused also, confessional statement. Now, under the BNS, Bharati Nagarik Suraksha Sanhita, under 183 BNS, the same statements can be recorded. So, when a magistrate has recorded that statement, etc., we need some sanctities, we automatically draw that presumption. So, here says, purporting to be signed by any judge or magistrate or by such officer as aforesaid, court shall presume that, what are the presumption? 1, the document is genuine. 2, any statement as to the circumstances under which it was taken purporting to be made by the person signing it are true. Remember, when a judicial magistrate say record confessional statement, when a accused want to give confessional statement and the magistrate record under 183 BNSS, earlier it was 164 CRPC, the magistrate has to certify as to he has cautioned the persons that if you are free not to make confessional statement, but if you make confessional statement, it shall be used against them, and the magistrate put a signature. That's what it says. The court shall presume it was made in those circumstances. Differently, cautioning has been done when a magistrate certified, etc. These are the statements which the person must have made. So, such evidence, statement or confession was duly taken. So, whatever the person has made a statement, only those things being taken by the magistrate. So, a statement recorded by the magistrate in judicial proceedings are admissible, and magistrate need not be called as a witness in all circumstances. But yes, some cases, magistrate do appear to certify that he has recorded the statement. So, this was held in Modi Ganga versus State, 1981 Supreme Court judgment. It further says section 80 does not guarantee voluntariness of a confession under section 24. Irregularities in recording a confession under 164 may be cured. So, there might be some irregularity which can be cured under the law. The next sections which talk about presumption of law, or the word they use shall presume, is about the presumption as to gazettes, newspapers and other documents. And it provides that the court shall presume the genuineness of every document purporting to be official gazette or to be a newspaper or journal, comma, and of every document purporting to be document directed by any law to be kept by any person. Such document is kept substantially in the form required by law and is produced from proper custody. So, again, there is a presumption that the document was kept the manner it should be kept by the public officials, and it was produced from proper custody. It has given explanation for the purpose of these sections, and section 92, document is said to be proper custody if it is in the place in which and looked after by the person with whom such document is required to be kept. But no custody is improper if it is proved to have had a legitimate origin, or if the circumstances of a particular case are such as to render that origin probable. We have seen in yesterday's, in the last lectures also, where a document supposed to be someone has asked his lawyer to keep the document with him. The custody which was with the lawyer, proper custody. The document which are relatives for protection, it has been kept, proper custody. So there are many circumstances will be there. The nature of circumstances indicate that it was kept properly for that protections. So then it is a proper custody. And there is a presumption about gazette, newspapers and other documents. So Supreme Court held long ago that the Gazette of Bombay Presidency published in 1879 is admissible under section 35 read with 85. Case name is Balasankar Mahasankar Bhadji versus Charity Commissioner. Similar way, so far as the newspaper and journals are concerned, the presumption is only about their genuineness but not about the truth of their content. Remember, suppose some article is published in the journal. Now, the presumption will be that this article has been published on that journal only, that volume, that year, etc. But the author which make those statements in those articles, no, there is no presumption with that regard. That okay, what the author says is completely correct. So the presumption is for one context, that what the law says. The same way when a physical gadget etc. draws some presumption, under 81 presumption as to gadget in electronic or digital record. So when similar kinds of gadget publications made digitally, nowadays almost every gadget notifications come digitally. There also the law says shall presume. So it's a rebuttable presumption of law, but it's a presumption of law, artificial presumption. So court shall presume that the genuineness of every electronic or digital record purporting to be official gadget or purporting to be electronic or digital record directed by any law to be kept by any person, if such electronic or digital record is kept substantially in the form required by law and is produced from proper custody. Explanation says, for the purpose of this section in 93, electronic record are said to be in proper custody. So the word proper custody also has been defined in the last section in 80. Here also they try to define that proper custody, which we normally consider or normal circumstances we consider to be proper, and the law recognizes them. Then presumption as to map or plan made by authority of the government. Now in the last video we have seen, if map or plan, published map by some private enterprises etc., it is may presume, natural presumptions. But when a map or plan made by authority of the government, then it is shall presume. So the court shall presume that the map or plan purporting to be made by the authority of the central government or any state government were so made and are accurate, but map or plan made for the purpose of any cause must be proved to be accurate. Now, many municipality, they prepare the map of their municipal areas. So, for example, in Kolkata municipal corporations in early 90s, 1904, 5, 6, 7, those point of time, they did made a map of whole Calcutta and it is available in the municipality office. Now, because it was prepared that point of time to have a map of the whole city, those certified copies by which those map can be proof, and the court shall presume that is a true depiction of the map which is there with the Kolkata Municipal Corporation, because that time the government agencies prepared those maps. So again, when it is prepared by the governmental agencies, law says shall presume, presumption of law, artificial presumptions. 83 talk about presumption as to collection of laws and reports of the decisions, again shall presume. So court shall presume the genuineness of every book purporting to be printed or published under the authority of the government of any country and the contain any of the law of that country, and of every book purporting to be contained report decision of the court of such country. So these are presumptions in their favor. Same way, presumption as to power of attorney. Many times this power of attorney being signed by the notary public. So the court shall presume every document purporting to be a power of attorney and to have been executed before any authenticated by a notary public or any court, judge, magistrate, Indian consul, vice consul, or representative of the central government was so executed and authenticated. Remember, many of you among CLAT aspirant might apply to some college where NRI sponsor seats are available. Now, when you apply for NRI sponsor seat and when you are going to get admissions, there's one of the requirements are that the person NRI who is sponsoring you, he will give an affidavit. Who will sign that? Either Indian consul or vice consul in the other countries where the persons reside. So he will give affidavits. What's the presumption? The presumption is the person has duly executed that power of attorney or other document or notary public things. So some kinds of presumptions may be there under the law. Now, power of attorney, when we say it's governed under the Power of Attorney Act 1882, under the old evidence law, the court is bound to take judicial notice of all seals of the functionaries mentioned therein, including seal of notary public. This judicial notice provisions is under the new law. It is there under section 51 and 52. Under the Notice Act 1952, notice public could be appointed by the central government or by the state government for all recognized notarial purposes. So, section 85 applies to notaries public of foreign countries also, and so there are many cases where court has followed it. Now, under 85, presumption as to electronic agreement. So, the court shall presume that every electronic record purporting to be an agreement containing the electronic or digital signature of the parties was so concluded by affixing the electronic or digital signature of the parties. So, there is a presumption in favor of the agreement signed electronically. Remember, nowadays we have a concept of digital signature where a person get specific digital signature through which they can sign agreement. Nowadays, many even the returns to the under the Companies Act or under the Income Tax Act, etc., it has to be done by the digitally signed. So then when they can, compliance can be made, similarly agreement can also be made. In the same way, presumption as to electronic record and electronic signature, 86 talk about those electronic record or electronic signature presumption. Clause 1 says, in any proceeding involving a secure electronic record, the court shall presume, unless contrary is proved, that secure electronic record has not been altered since the specific point of the time to which the secure status relate. So those are secure electronic record, protected electronic record. Many times we do transactions, banking transactions, RBI transactions, some other transactions which are there under Companies Act, some transactions being conducted. In any proceeding involving secure electronic signature, the court shall presume, unless contrary is proved, that the secure electronic signature is affixed by subscriber with the intention of signing or approving the electronic record. B. Except in cases of secure electronic record or a secure electronic signature, nothing in this section shall create any presumptions relating to authenticity and integrity of electronic record or any electronic signature. So, this 86 is completely talking about secure electronic record. 87, presumption as to electronic signature certificate. We know under the Information Technology Act, read with Indian Evidence Act, now Bharatiya Sakshya Adhiniyam, there are processes by which the digital signature can be issued. So, there are certifying authorities which issue digital signature. So, when the certifying authorities appointed by the government issue digital signature, this provision 87 talk about the court shall presume, unless contrary is proved, that the information listed in electronic signature certificate is correct, except for information specified as subscriber information which has not been verified if the certificate was accepted by the subscriber. So there are some presumptions. Now again I said these kinds of presumptions normally helps in proving something in court. Otherwise, all these evidences need to be produced in court. So it saves time. 91. Presumption as to due executions of the document not produced. Now, very important sections. Now, these sections, we cannot see this in isolation. under the Bharatiya Sakshya Adhiniyam, same provision was there under Indian Evidence Act also. Suppose three brothers and sisters are fighting a civil dispute. The title deed is with the brothers, and brother somehow there is an impression that he doesn't want to give the share to their sisters. Now sisters file partition suit for the property. Now you need those title deeds. Now title deeds in the hands of the brother. Now those sisters might have a Xerox, might not have a Xerox copy of it. So suppose if the sisters want to give Xerox copy, there is a requirement that if the original document is in the hands of the adverse party, first you need to send notice to those adverse party to bring those documents. And if they refuse, then you can have a right to give secondary evidences. Now here the presumption has been added. So the sister sent notice to the brother by virtue of court order to bring the original. Brother did not bring. Now the trial going on, sister submitted the secondary evidence, a Xerox copy of. Now they cannot challenge. The court automatically draw in presumption that it was properly attested, properly stamped, properly executed. So when these presumptions are there, that means it is proved that it was properly attested, stamped and executed. Now it is shall presume, that means rebuttable presumption of law. Other party want to prove otherwise, let they come and give evidences. But there shall be presumption that it was properly stamped, properly executed, properly attested. So this notice to produce referred to in section has been read in conjunction with 65A and 66. This was basically old law. The presumption is of course rebuttable, though the court is initially bound to draw it. The presumption does not extend to the correctness of this content. The section is founded on the maxim omnia presumuntur contra spoliatorem. It is based on the principle that nobody shall be allowed to take advantage of his own wrong. So the other party has been given opportunity to bring original. Now the party has not brought, and accordingly the sister was allowed to submit Xerox copy, secondary evidence. Now they should not be allowed to give benefit for whatever the wrong they have done. 108 says, burden of proving that case of the accused comes within exception. Now remember this section is within the chapter of burden of proof, and within the chapter of burden of proof, start from 104 onwards of the Sakshya Adhiniyam. 108 says, firstly it said that if anybody wants to claim or asking for some claim that their case fall into general exception, we know in Nyaya Sanhita there are many exceptions. For example, right to private defense. Everyone has right to exercise their private defense. There is other circumstances also, good faith protections. So if the case falls under the general exceptions, the burden of proof those general exception lies with that persons. And the last line says, if the accused did not bring any evidences to take advantage of general exceptions or claim that his case fall in general exceptions, then court shall presume absence of such circumstances. Court shall presume no such circumstances was there. No general exception does not exist in this case. So that kind of presumptions can be taken by the court. If other party want to rebut this presumption, it's open to them, but presumption shall be drawn. Same way, dowry death. Now, in the last video, you have seen my comment about abatement to suicide. In case of abatement to suicide, it says may presume, but in case of dowry death, law has used the word shall presume. So whenever the questions comes whether the in-laws are responsible for doing dowry death, etc., in those circumstances, if some basic facts are proved, like there was a marriage within 7 years, there was a dowry demand, there was a harassment or torture, cruelty, etc. Now in those circumstances, court shall presume that in-laws were responsible for committing dowry death. 120. Presumption as to absence of consent in certain prosecutions for rape. I was discussing this in the yesterday's last videos. In any sexual offences cases of rape, etc., if a woman give evidence in the court that she has not given consent, court shall presume that she did not consent. Now, if the man want to prove that there was a consent, burden of proof on him to prove it. So, very powerful provisions. We know this all 120 is now in the new act. Earlier it was 114A. Now, under these sections, it was started that point of time after very famous Tukaram case where allegedly police officer has committed rape of a helpless woman of a village who went to police stations because some her friend was detained by the police, etc. So, and there the court has acquitted that police officers on the ground that she might have given consent. And there are lots of hue and cry throughout the countries. You will find this case in Google. If you search, you will find this case, normally called as Mathura rape case. So, in that case, after that, when the agitation started, this presumption was added in section 114A, and the law says court shall presume that there was no consent. So, the girl give a statement that she has not given consent, court shall presume that there was a no consent. In Dowry death case, this is a very famous case, State of Andhra Pradesh versus Raj Gopal Asawa, 2004 judgment. Trial court convicted the offenders under 498A and 304B. Though it was noticed that there was no direct evidence against accused number 3, the husband making any demand of dowry, his silence was constituted to be an act of endorsing demand, and he was, as noted above, held guilty. High Court holding that to be not guilty of the alleged offence as demand soon before not established, no agreement entered before the marriage. It was further submitted that no grievance had been ever made before DW1, the eldest member of the family. So those were there. Now Supreme Court says the offence alleged against the respondent is under 304B IPC, which make the demand of dowry itself punishable. Demand neither conceives nor would conceive of any agreement. If for convicting any offender, agreement for dowry is to be proved, hardly any offender would come under the clutches of the law. That's rightly Supreme Court has observed. So both section 304B and 113B of the Indian Evidence Act were inserted just to tackle this menace of dowry death, and accordingly, because of the presumption clause, it helps in proving the case against the accused, and Supreme Court found the accused guilty. There are many special laws also under which the law declares some presumptions, and that presumptions helps in proving the cases. For example, under Immoral Trafficking Prevention Act, Section 3, Clause 2A, draw and presumptions in favor of the owner of the premises where the prostitution is going on, that they have a knowledge about the presumption in certain circumstances. If those two criteria are fulfilled, if a report published in the local press about the misuse of the revealed during search, or such seizure list, etc., hand over to the owner, so there could be presumption in those circumstances. Under Section 4, if anyone is always leaving a woman in prostitution, even in those circumstances, court may presume that there was the person is living on the earning of prostitutions, and there's by presumption may help in proving the cases. Section 4 can be used against the pimp, tort, many other people. So there's a presumption against them. Section 6, there is a presumption that someone has kept a girl for the purpose of prostitution in the brothel. And POCSO, these are very important sections are there. Section 29, 30, we talk about the presumptions. So for the more heinous offences of penetrative sexual assault, aggravated penetrative sexual assault, aggravated sexual assault, the burden of proof is shifted on the accused under this act. So one section talk about actus rea presumptions. When a person is being prosecuted, court shall presume that such person has committed offense. Another section talk about mens rea presumptions. The person must have that kind of mental state in which they have committed offenses. And because of these 229, 30 only, we are finding in large number of cases the persons able to be convicted. Now we come to this last part, artificial presumptions or irrebuttable presumption of law. I said in the Bharatiya Saksha Adhiniyam, only two sections are there. First section is 35, which talk about the relevancy of certain judgment in probate, etc. So these category of cases, probate, matrimonial, admiralty, insolvency, in these cases, the outcome of the case gives some status, some tag, and accordingly, those status which the new status the persons got, court will consider them as a conclusive proof. So they are conclusive proof of the fact. So such judgment, order or decree is conclusive proof. 1. Any legal character which it confer, any legal character to which it declare any such person. 3. Any legal character to which it takes away from any such person. 4. Anything to which declare any persons to be entitled to in probate matter. Someone become absolutely owner of the property once the probate is granted. So it is conclusive proof of the fact that the person is absolutely owner of that property. That's the presumption. So it's a highest standard of presumption which is there. The issue arises with the refuse of probate also will be create some kinds of presumptions. Sarkar in his book referred to that finding in probate proceeding that the due execution of a will has not been proved should not be treated as final decision upon the genuineness of the will and will not preclude a fresh application. In those circumstances, a fresh applications can be made. The last section which talk about the presumption is birth during marriage, conclusive proof of legitimacy. In the last video also I discussed about it. So if a child born during subsistence of marriage, court shall presume that the child belong to that couple. So section says the fact that any person was born during the continuance of a valid marriage between his mother and any man or within 280 days after his dissolutions, the mother remaining unmarried shall be conclusive proof that he is the legitimate child of that man, unless it can be shown that the parties to the marriage had no access to each other at any time when he could have been begotten. So if the other party can prove that the person has no access, then different thing. But if they are living together, they are together, then court is a conclusive proof that the child belonged to them. And accordingly, this provision was incorporated neither for the women or for the man, it is for children. Because even if the mother might have some illegitimate relationships and the child might be not really the child of the husband of that lady, but the child has not done any wrong and accordingly child needs protection. So this section is for protection of the child, that the court is the conclusive proof that the child belonged to them. And accordingly, this is a very famous case, Kamti Devi versus Poshiram. Issue arises, can we go for medical examinations for paternity test, etc.? Supreme Court says that no, it's a conclusive proof. So in order to going for medical examination, first the other party has to prove that they don't have access to each other. If the access to each other is there, then court, there's a conclusive proof. It's a presumption of legitimacy, child belong to them. So that's basically two sections are there which talk about irrebuttable presumption of law. So what we discussed in these videos was irrebuttable presumptions of law and rebuttable presumptions of law. Shall presume, there are large number of sections where the word shall presume is used and two sections where the word conclusive proof is used. So thank you. Again, we'll meet in another video. Thank you. Thank you everyone.